Judge Glacier, I do see that we have the attorney for the plaintiff and one of the attorneys for the defendant, as well as the court reporter, so I can bring them in if you're ready.
Well, maybe we can check with the attorney for the defendant who's here to see if more than one attorney is going to show up. I don't want to start if there are going to be two of them.
Okay, I can work on that, okay?
See if there's another one coming. And then if they're ready, if you check with them and they're ready, we can start.
Okay, I will check.
I'm here. Thanks, Morgan.
Okay, so it looks like the two attorneys will be on the same video camera, so they're ready.
Okay, great. Well, let's get everybody in and we can call the case and get going.
The cameras are on, right? Yeah. Do you care?
We're all good.
All right, you're all good?
Yeah, we reviewed it.
All right, we'll do that then.
All right, good morning, council. It looks like everyone's here. Can everyone hear me and see me okay? Everybody good? I know Morgan does a great job at the tech stuff. Just want to double check. All right, good morning. Let me call the case. It is Atsalis Brothers Painting Company versus Michigan Department of Transportation, Court of Claims, docket number 20-172-MK. And we're here today because I wanted to hear argument on two motions that are pending for summary disposition. I want you to know, counsel, that I've read the motions carefully. I've discussed them with my law clerk. I've dug in as much as I can into the multiple pages of attachments. I've tried to learn as much as I possibly can from the materials that you provided about bridge painting, which, you know, frankly, is a little bit more interesting than I thought it would be when I began this project. That said, I do not want to cut you off or constrain your arguments this morning. So I'd like to, I have as much time as we need. I'm not in any rush. And I want to be sure that my questions are answered and that you have an opportunity to say what you need to say. So let's do one at a time. And let's start with the state's first motion for summary disposition. And let me focus you a little bit, if that would help, because, you know, as I said, I've read it and I've thought about it quite a bit. So it seems to me that the issue presented in the first motion is whether or not Atsalis timely notified the department of the dispute that had come to the fore about how much work was supposed to be done, or I should put it this way, the nature of the work that was supposed to be done, whether this was a complete blast cleaning of all metal spans of the bridge, or just certain areas of the bridge? So the first question, the timing of the first question was in December of 2018. And at that point, Atsalis had only been working approximately a month on the project. So it raised the question timely. And it seems to me that the answer on the whole question of notice, whether the subsequent notice was filed timely, depends on the specificity of the response of Mr. Lambden. So I'd like you to address that. And I'll tell you right at the outset that I'm not clear or convinced at this moment that Mr. Lambden's response to Atsalis's query put Atsalis on notice that the work that was required was the total and complete blast cleaning of every area of that bridge. So with that, take it forward.
Thank you, Your Honor.
And I forgot to ask, I'm sorry, could you identify yourselves for the record too, just so that we know, and whoever's speaking, just say that so that our court reporter can make a good transcript for us.
Yes, Your Honor. I am Assistant Attorney General John L.A. Tuttle, appearing on behalf of MDOT, and with me is my co-counsel, Assistant Attorney General Eric Kahn, also appearing for MDOT. With regards to the first.
Excuse me, Mr. Khan, can you spell your last name?
Yes, it's spelled C-O-N as in Nancy, N as in Nancy.
Your Honor, for the record, Anthony Vitilio for the plaintiff.
Thank you, Mr. Vitilio.
Okay, moving on, Your Honor. And I will very much address your question regarding the specificity of MDOT's response to the RFI in the course of my oral arguments. So I'm sure the court is familiar with Joseph Heller's novel Catch-22, and this motion brings to light a Catch-22. Atsalis seeks excess compensation under the contract, and to get it, Atsalis needs a contract dispute. But the very contract dispute that triggers, but it is that very contract dispute that triggers the contract's notice requirement. A notice requirement that Atsalis failed to abide by in every instance, thereby waiving its claims. Now, standard specification 10410 is incorporated into the contract and in MDOT's dispute review board procedures, or DRB procedures. 10410 requires that all claims be preceded by a written notice of intent that must be submitted, 1, before beginning the work or upon encountering the circumstance that is the basis of the claim, or 2, within 3 calendar days after the beginning of a delay for which the contractor intends to seek compensation. So in other words, right at the start of the work or encountering the circumstance, or if a delay is involved, within 3 calendar days of first encountering that delay. According to both 10410 and the DRB procedures, a failure to provide proper notice of intent constitutes a waiver of those claims and renders any decision by MDOT to be final and binding. Now, moving to the claims proper, there are 2 claims submitted by Atsalis. There is a March 12th, 2020 claim, and there is a May 28th, 2020 claim. The May 28th, 2020 claim is a post-termination compensation claim. No notice of intent submitted for post-termination at all, for post-termination compensation at all. So there's no notice of intent for the May 28th claim. The March 28th claim is really the substance of the extra work claims. The March 12th claim, to be clear, I'm sorry if I'm mixing any of these up. The March 12th claim has 6 impacts, as Atsalis phrases it. And they're really they're substantive arguments. That is cardinal change, cleaning and coating extra work, platform extra work, Scotch coat extra work, extension of time, and liquidated damages. Now, of those 6, there's really only 3 that the court has to examine closely, because the other three, well, 2 of those are rehashes of other claims. And the first one, the cardinal change, is not even recognized by Michigan courts. So, Your Honor, I will move right into those, the substance of those claims. And I'll reserve a little bit of time, if I may, for the allegation that MDOT somehow modified the contract. And I can address that later. But moving on to the claims, the substance of the claims in the March 12th claim letter. Section 3 deals with cardinal change. Now, right in the text of this claim, it states that, Atsalis is arguing that MDOT's interpretation of the cleaning and coating special provision and the platform special provision amounted to a cardinal change. So really, this is just a rehash of its claims concerning the cleaning and coating work and the platform work. And Michigan courts, they do not recognize the doctrine of cardinal change. I'm quoting here: the doctrine of cardinal change in a government contract has not been recognized by the courts of this state. That's L. Lower Construction Co. versus Department of Transportation. It is an unpublished opinion of the Court of Appeals, and it was issued September 23rd, 2010, docket number 294067. And we can provide a copy of that if you like, Your Honor. Moving on, the cleaning and coating extra work claim. This is section 4 of the claim letter, and this is the real substance of MDOT's motion. Now, Atsalis alleges that MDOT's insistence on interpreting the cleaning and coating special provision to require 100% blast cleaning was a directive to perform extra work, right? It argues that it reasonably bid the project to require only 15% spot blast cleaning, not the 100% cleaning that MDOT understood the contract to require. Now, to the substance of the claim that you were particularly alluding to, RFI number 6, Your Honor, and MDOT's answer to the RFI. RFI 6 brought the contract dispute to light. RFI 6 was submitted on December 17th, 2018, and it was answered the next day on December 12th, 2018, right? And Atsalis submitted its notice of intent on July 23rd, 2019. And that's a great deal of time afterwards. Now, Atsalis knew that its notice of intent would be late. And so it drafted a letter in July 19, 2019 to fabricate an event that would trigger the notice of intent requirement.
Let's stop that. Let me stop you, because it seems to me we're skipping over the response that Lambden gave to the request for information. And really what we're trying to do in a motion for summary disposition, it seems to me, is find a point in what you're trying to do, is find a point at which there is no factual dispute about whether Atsalis began work or encountered a circumstance that then became the basis for the claim. So it seems to me you want to find a point that is more than, that is too far back to allow Atsalis to proceed with this lawsuit. I understand that. The point the point in time that you've pointed to, or that you've identified, is this RFI. So it seems to me that in order to proceed or in order to succeed in arguing that the response to the RFI put Atsalis on notice, that response has to say you were supposed to do cleaning and coating and blast cleaning and coating of everything. Am I right? And it doesn't say that.
Yes, Your Honor.
Okay.
Okay,
The problem that
can-
I have, it doesn't seem to say that. Yes, the blast cleaning and coating is obviously the center of Atsalis's notice when the one that it, eventually filed. And it seems to me that it likely is the center without having evaluated all of the damages, but it's likely the center of most of its damages claims. So focusing in on that, where does Mr. Lambden say you're supposed to blast, clean, and coat every single bit of that bridge? Because I don't find it in there.
Yes, Your Honor. And I can address that. And I believe the July 19th letter does address that, but that I was referencing. But I will quickly explain somewhat of the process and why the answer to the RFI was phrased the way it is.
Okay.
A part of the contract, all MDOT contracts state that the contractor is in control of the means and the methods of the work. And so if MDOT at any time directs a contractor to use different means and methods, then that can be viewed as a direction of work. And that can be viewed as a circumstance requiring extra compensation. And it's a common practice for contractors. It happens frequently, right? Where MDOT explains the work that has to be done and a contractor claims that that's somehow a means and method direction. And so MDOT is very careful on how it answers its RFIs, and it uses as much as possible the contract language so that there can be no claim that MDOT is directing means and methods. That's why the RFI is phrased using contract language, as opposed to just using plain speech and saying, hey, we mean 100% of the bridge. Because had it used anything other than contract language, there could be an argument. And there generally is, even on the simplest terms.
What would that argument be about?
Well, it's a general practice that MDOT has, Your Honor, is what I mean to say. So MDOT believed that the contract required 100% cleaning and coating work, and so it used the contract language. And to avoid an allegation that it was somehow bringing in other language outside of the contract, it does its best not to do that. But if I may, Your Honor, move.
But okay, that's fine. All right, first of all, let's look at that response. You can tell me what I'm missing here, but first of all, the response is, and Atsalis's question, by the way, I found very clear. There was nothing nuanced or difficult to parse about Atsalis's question. They wanted to know if they had to clean the whole thing, or in their view, they posited, after referencing 3 plan sheets, this clearly states that only areas of bare or rusted steel and damaged coating is to be blasted. So there's the question. So the first sentence of his answer references the special provision for cleaning and coating existing steel structures was written as a supplement for section 715. My first question to you is, I don't think 715 is in the record. I'm not sure I need it, but it's not. The law clerk and I have scoured this record and it's not there. So just know that. So whatever he's referencing here, I don't know what it is. Okay, fine, whatever that is. And we've read the cleaning and coating existing steel structures. I've read it and it doesn't answer the question. So then he says, this supplement was written to make it clear that steel grit or shot are not acceptable material for blast cleaning. And that's fine, but that doesn't answer the question. The question wasn't about the material for blast cleaning. The question was about the extent of the blast cleaning. The next sentence is, in the measurement and payment section of this special provision, it states that the work shall include complete blast cleaning and coating of the structure directed by the engineer or as indicated on the plans. And that again, doesn't say everything. It says as indicated by the engineer, which to me is precisely the guidance that Atsalis was asking for when he sent this RFI. Then it says the spans indicated above clearly show which spans are to be cleaned and coated, which, you know, granted, I'm not an engineer and I'm not a painter of bridges, but when you use the term which spans are to be cleaned and coated, it seems to me you're saying that not all of them need to be. Here's some drawings that show which ones need to be. And then the last sentence is totally unresponsive to the question, as far as I'm concerned. The quantities, well, that doesn't tell me anything about how the quantities of coating doesn't tell me anything about the extent of the blast cleaning. So tell me what I'm not understanding about this response. It is in English, but I just don't get it.
Yes, Your Honor. And I understand where you're coming from because there's much context in those answers. There's much engineering context and there's much cleaning and coating work context.
Let me stop you for a second. Doesn't that fact, that admission on your part, mean that I can't grant summary disposition?
No,
Summary
Your Honor.
disposition, okay, tell me why, if there's much context behind it, and that you can't use the face of the words to say there's no dispute of material fact.
Yes, Your Honor. The reason being is that the existence of a dispute is all that's necessary. So all that's necessary is that there is the existence of a dispute between all cleaning and partial cleaning, and the completeness of the answer itself goes more to the adequacy of the contract, and that is the substance of another motion. So just so you understand, Your Honor, and I understand that it wasn't presented for the purposes of this motion. There's a lot behind that answer. The contract required a 3-coat system that requires that all the paint be removed before you can apply it. There's a zinc-based primer that has to be applied to bare steel. So you can't even apply it unless you remove all the old paint. It has to do with the nature of limits of work that are in construction plans. When they give you a limit of work, that whole area has to be done. There is the fact that the standards.
Tuttle, you're convincing me as you go on that there are more and more questions of fact here.
Yes.
I mean,
Okay.
you're throwing questions of fact, but here, let me just tell you my perspective on this. And it seems to me that, yes, you are right, that this, in the sense that this RFI did bring a possible dispute to light, a possible dispute. The answer, it seems to me, didn't really respond in a way that was clear. It's not clear to me, and I know that the lawyer, that Mr. Vitilio is going to say it wasn't clear to Atsalis. So then what happened, it seems to me, and this is where I want you to, both of you, both counsel, all counsel, to help fill in the blanks. It seems to me that what happened, first of all, this was December, so work probably stopped, right? Or it wasn't going on at this point, or it probably stopped shortly thereafter for the winter and picked up again in the spring. And then sometime in the spring, the whole dispute comes to light again. And Atsalis is told to do told to clean the whole thing, blast clean the whole thing. It comes to light again. And there are probably disputes of fact about that too. And then eventually it winds up with the notice that Atsalis finally files. But this answer does not tell me that Atsalis was on notice that it had to blast clean the entire bridge. And does that make sense?
Yes, Your Honor. Atsalis, on the exterior steel, Atsalis never did anything but blast clean the 100% of the exterior steel. They started the work by completely blast cleaning span 1. And when they picked up, they completely blast cleaned everything else. And
And
that's,
by the way, let me stop you. I would assume that the work involved in span 1 is not part of their damage claim. Am I right about that?
no, I believe it is, Your Honor. It is.
Okay,
Yeah.
okay,
They,
okay, all right.
yes. Yeah, they claim that their foreman, it was in the Manos affidavit, they claim that their foreman didn't know what he was doing, but
Yeah, I did read that, but I didn't realize that despite that, they were still including that as a claim for damages. But anyway, that was the little frolic and detour. Continue, if you
Yes.
would.
The notice of intent in July 23 of 2019 is preceded by a series of letters, Your Honor. And really, the important letter here is July 19th. If you look at the July 19th letter, it's Exhibit M to the Manos affidavit. So Atsalis knew it had been cleaning and coating 100% of the bridge on the exterior ever since it started. It knew it had been doing this. It knew that it submitted an RFI back in December, but it needed to make a timely notice of intent for a claim. So they wrote a letter. They wrote a letter on July 19th, 2019, and I quote that letter, Your Honor. Please advise if the department intends to continue to direct Atsalis Brothers Painting to completely blast, clean, and coat all exterior surfaces of the structure in lieu of the cleaning and coating existing steel structures special provision from the
I'm
contract.
glad you brought that up. Yeah, and to me, that language is is critical. I agree with you. That's really very critical language. The question is, when did the department first tell them that all of those things were necessary? And the department right now is hanging its hat on the December 18th Lambden response, and I'm saying I'm not convinced that that tells them that they were supposed to do all the work they're now complaining about having had to do. So there has to have been a different day, it seems to me, or a different point in time, and I don't know when that was. And it doesn't matter for the purposes of this motion.
So, Your Honor, according to the Manos affidavit, and I direct you to paragraph 27, it states, the foreman on the project for Atsalis at the time was retiring from employment. During the work on span 1, he followed the direction of the on-site inspector to blast clean all of the exterior steel. Our foreman was not aware of the express language in the SP special that enumerated that only areas of bare or rusted steel and damaged coating are subject to the SP special. So according to Atsalis.
Can you read that last part again? You went a little fast. I didn't hear your words. That enumerated that only areas
of bare or rusted steel and damaged coating are subject to the SP special. So in other words, according to Atsalis itself, its foreman did the work of 100% blast cleaning because MDOT's inspector told it to. So it was that was the whole point of their RFI. Hey, your inspector came and told us to paint this whole span 1. So we did it. Well, we read the contract and we don't think it requires 100% blast cleaning like we did on span 1. We think it requires spot blast cleaning. And so MDOT answered back with the contract saying, no, there's the contract. So it was aware that MDOT's position was 100% blast cleaning. And Your Honor, I'd like to point out the difference here. It's not a trivial matter. This is not like a side note of the contract. Atsalis' own claim letter, its March 12th claim letter, points out that the difference here is $22 million. According to its own claim letter, the last page of the claim letter, it says that the two different interpretations of the contract result it says it results in an $11 million difference for the half that they've completed. So they say that doubles if you want us to do the rest of the work. So according to Atsalis, you've got a $22 million contract dispute. And the only reason they did 100% of span one is because MDOT's inspector told them to. And as a result of that, they wrote MDOT and said, wait a minute, we don't think we have to do it. MDOT responds in the manner here. Granted, we could have done a better job of explaining how complete that answer was. But then Atsalis went off and did 100%. Always has done 100%. And so on July 19th, they write a letter that says, hey, are you going to continue to direct us to do 100%? And MDOT's response is, what is MDOT's response? MDOT's response was, we already told you to do it in the RFI. And that's the July 22nd letter. And that's when Atsalis uses the July 22nd letter as a triggering event, as if it's a brand new revelation to it, that MDOT wants 100% cleaning and coating work. Now, we could provide so much more, Your Honor. We could provide all the IDRs that show it did 100% blast cleaning on the exterior during this time. It did 100% blast cleaning underneath the deck before this work. We went through and pulled all those RDIs where the inspector recorded exactly what work they were doing. They admitted it. We did that. We recently conducted the affidavit of Gary Manos, the VP for operations. Pardon me. We recently conducted the deposition of Gary Manos, the VP for operations, the man whose affidavit is attached to this, to Atsalis' response. He admitted they never once did spot cleaning and coating on the exterior of the bridge. They always did 100%, and they always did it under the belief that MDOT was directing them to do it.
Okay, but now you're talking to me about, again, about facts that are potentially outside the record that's before me in terms of this particular motion. So let me, Mr. Tuttle, let me stop you here. I understand your position. Let's hear from Mr. Vitilio, and you'll have time to respond, Mr. Tuttle, I promise you. Okay?
Okay, thank you.
Mr. Vitilio.
Yeah, thank you, Your Honor. I really appreciate the focus on the procedure here on an MCR 2.116 C10 motion, because part of what we've been telling the court in our brief is that when a party files a motion claiming there's no genuine issue of material fact and then fails to present a complete record of what those facts might be, the motion should be denied. And here you have a situation, Your Honor, where we've responded to the motion with a wealth of documentary evidence that the department did not provide to this court. We've given the court an affidavit, and in that affidavit, specifically in paragraphs 28 to 49, our client and his project manager is detailing the facts and circumstances as to why it did not believe the response to RFI 6 answered the question. And it details the facts and circumstances that led to the July letter of Atsalis to the department, then HNTB's response, and then the notice of claim. And on the record before, Your Honor, those facts are totally undisputed right now.
Okay, let me stop you for a second, Mr. Vitilio. Is there evidence in the record now that substantiates Mr. Tuttle's claim that in fact your client was doing a complete blast clean and coating up until July of 2019?
Yes, there is. We can't. That fact is a fact, and we're not going to shy away from a fact that is in truth. And that fact's never been in dispute. And in fact, it's in our affidavit. So at Atsalis, we're not coming to this court trying to fabricate what may have occurred on the project. We're acknowledging that in span 1, it was a complete blast clean. We're acknowledging RFI 6. We're telling the court that when Atsalis got the response to RFI 6, we did not think that it addressed the question that we asked. And then the affidavit goes on to talk about Atsalis understood the term complete to mean a complete blast clean of steel to bare metal in the areas identified. And then it goes on to talk about how Atsalis viewed the response to RFI 6. And then the affidavit goes on to say why it wrote the letter in July. And then when the letter came back from HNTB, why Atsalis submitted its notice of claim. And so if we go back to the terms of the standard specification of 104.10, that requires notice of claim to be given before beginning the work or upon encountering the circumstance of the claim. That's what we're telling Your Honor, is that these July exchanges were the circumstance that give rise to the notice of claim. And that evidence.
How so if you'd already been doing the work?
Well,
If you'd
Your
already
Honor,
been doing work that you'd say you didn't need to do, how did those exchanges give rise to the claim?
because there was, and now this response, Your Honor, is not in the record before the court. We need to be mindful that these motions were filed in June 4th. And since June 4th, there's been additional discovery, additional depositions, which is another reason why the motion was premature. But to answer your question, Your Honor, the question of if they were completely blast cleaning all the steel, why is that? Well, there's miscommunication between the internal people at Atsalis about whether and what amount of scope of work this contract required. And opposing counsel references a recent deposition of Gary Manis, and that's what he said at deposition. So just because a contractor may be performing work gratuitously, for lack of a better word, doesn't mean that contractor is obligated to continue to perform gratuitous work once that contractor wants to assert its rights under the contract. And it seems that's the situation that's presented here in this case. And so, you know, with respect to how the department initially began its oral argument here, I mean, right away, they're starting to argue issues that just go beyond the scope of their motion. And they're mentioning the May 28th claim of Atsalis when the first motion for summary disposition had nothing to do with that. And he's saying that Atsalis knew its notice of claim would be late, and that's why they generated the July letter. There is zero evidence in the record before Your Honor to support that assertion.
Let me ask again, Mr. Vittilio, because I'm not clear on your answer. And it's probably me, but let me ask again. So 104.10 says, qualifies basically that if you want to file a timely notice of intent, it has to be submitted before beginning the work or upon encountering the circumstance that is the basis of the claim. What I just heard you say is that for months before the notice was filed, Atsalis was doing work that it understood was disputed with regard to the extent required. And if that's correct, how is that then a timely notice? What am I missing?
Because the premise that Atsalis knew it was disputed at the time it was performing on span 1 is incorrect. Atsalis's crews, Atsalis's project manager did not have an appreciation for the special provision language and the manner in which Atsalis bid the job.
So then when did that knowledge become available to Atsalis?
In the spring of 2019, as Atsalis was beginning to head into the substantial portion of its cleaning and coating work, just as the affidavit of Mr. Manis attests to. And that's why he sent the letter in July.
Would I be correct in understanding that whenever Atsalis did have this epiphany about the work, that's when the clock started running on the notice.
I would say that the clock began, according to the contract, the circumstance giving rise to the claim. So I would say, Your Honor, that the circumstance giving rise to the claim is the letter that came back from HNTB. That's
Well,
how
it
I,
also says before beginning the work, and I would assume that is before beginning the disputed work.
I would agree with that, Your Honor. It's either or. So that's how I read the standard specification in that regard. And so that's what our affidavit attests to on the issue and notice. And again, for purposes of a C10 motion, what we've set forth, Your Honor, is not disputed by any affidavit or testamentary support by the department. And so at the very least, an issue of fact exists on timely notice, and that just pertains to the additional blast cleaning work. The department would seek to dismiss the entirety of the claim that relates to the platform load restrictions, which is just as significant as the added scope. They would seek to dismiss the differing site condition claim. They would seek to dismiss the imposition of liquidated damages, all because of their argument that timely notice wasn't given for the special blast cleaning claim. And so even if Your Honor does think that there are no genuine issues of material fact with respect to timely notice for the special blast clean, the entirety of the claim does not get dismissed, because there are discrete issues presented in that claim for which other notices were given under the contract. On top of that, Your Honor, what we've asked the court and what we've presented to the court, we've asserted and argued, Your Honor, that there is clear and convincing evidence of modification on behalf of the department.
Okay, I don't think I need to go there, but I understand your argument. Let Mr. Tuttle respond, and then we'll move on to the second motion.
Okay, thank you.
Thank you, Your Honor. So I would just like to point out that counsel for Atsalis admitted that they did 100% blast cleaning throughout the course of their performance from the very beginning of span 1 through the time of the notice of intent. I would also, Your Honor, like to stress that the discontinuity of Atsalis' argument in regards to when Atsalis understood that it required 100% blast cleaning. On the one hand, they want to claim that their VP of operations, Gary Manos, only discovered this in the spring of 2019. On the other hand, they want to assert that it is George Atsalis, the one who submitted the bid, who understood from the very beginning it was only spot cleaning. And that's the whole basis of their claim, is that they bid this job at spot cleaning. And yet they now admit that their VP of operations didn't understand and thought it was 100% cleaning. So there's even a contract dispute between the members, the executive members of Atsalis. I mean, it's bordering on absurd in an effort to try to preserve a contract claim, yet avoid the requirements of notice. And again, Your Honor, to make clear, I understand a lot of extra material was brought in. Atsalis' co-counsel, or pardon me, let me slow down a bit, Your Honor, I'm sorry. Esteemed counsel has brought up that Gary Manos' affidavit revealed certain things. So even Atsalis has brought in extra material. To make it clear what's before you and in this motion. According to Atsalis, MDOT's inspector directed Atsalis to do 100% blast cleaning. And they did. And that we dispute that, but we take that as true for the purposes of this motion due to the procedures of a C10 motion. Now, Atsalis then submits an RFI number 6. That's not in dispute. MDOT answers RFI number 6. That's not in dispute. After MDOT answers RFI Atsalis continues to do 100% blast cleaning. That is now
not in the record. let me stop you. That's not in the record. I don't know anything about that because nobody told me that.
Okay, yes, Your Honor. You've heard it from Counsel for Atsalis here, and it's also evidenced by the July 19th letter saying, are you going to continue to have us do that? There is evidence in the record before you. Exhibit O to the Manos affidavit has a contractor update. This is a business record. The contractor update is provided by Atsalis. So in other words, it's a statement by a party opponent. And it states that an overview of the work completed since May 1st, 2019. Cleaning and various stages of coating on the north and south tie girders,
I'm sorry,
installation.
can you slow down? I can't hear your words. Cleaning and what?
I'm sorry, Madam Court Reporter. I will slow down.
May 1, 2019, cleaning and
various stages of coating on the north and south tie girders, installation of the quick deck system at various locations / levels, cleaning and prime coat application of the girders under the deck from panel point 19 to panel point 27. Intermediate and top coat application also started on these girders and are at various stages of completion. The zinc has to, I believe it's in the record, Your Honor, the zinc has to be applied to bare steel. You can't apply zinc unless you get bare steel. There, we can easily remedy the situation presented, Your Honor, by providing exhibits to show that all the work was done as admitted by Atsalis's counsel. I would like, it with the time I have, Your Honor, to move on to the other claims at issue, because we were prepared and are prepared to speak to that. There's a couple of reasons why MDOT's motion did not spend much time on the other claims and the other substantive impacts. First, MDOT's motion certainly did mention that the May 28th claim did not have a notice of intent filed for it. Secondly, regarding the other impacts, we talked about the extra cleaning and coating work. Regarding the platform extra work, the notice of intent for the platform extra work on its face is late. All you have to do is read the notice. The notice itself acknowledges that Atsalis had been performing the work under the alleged conditions that entitled it to extra compensation. The notice itself references a November 7th meeting during which Atsalis asked MDOT to point out in the contract where the loading restrictions were included. Now, the notice of intent was filed November 26th, and it states, hey, we brought this to your attention on November 7th. We asked you to point out where in the contract these loading restrictions are, and you couldn't do it. Right there, on its face, that notice of intent is late because they should have done it on November 7th. The notice of intent should have been filed on November 7th, right after that meeting. There's also other exhibits before the court that point out that this dispute had been ongoing. Exhibit O to the Manos affidavit, Exhibit X to the Manos affidavit, Exhibit Y to the Manos affidavit. They all speak to the fact that this platform issue had been ongoing long before they filed their notice of intent. With regard to the changing conditions, Your Honor, the reason MDOT did not spend a great deal of time on that is specifically because that work is included in the extra cleaning and coating work. If you look at the plans, and this is Exhibit D to the Manos affidavit, it specifies, and it's relied upon by Atsalis, it specifies portions of the bridge are coated with 3M Scotch coat encapsulation coating, Polynox 136. The additional effort to clean the structural steel will not be paid for separately, but we will be considered included in the bid items. Now, removing the Scotch coat was required under the contract as part of the cleaning work. MDOT made no representations as to how much was on the bridge or where it was located, how it was applied. The the notice of intent alleges that it created production delays because it was applied in a manner thicker than the manufacturer's recommendation, right? So Atsalis had submitted this notice of intent on July 30th, 2019. That's 8 months after it started the cleaning and coating work. It's that in and of itself is a super late notice. If you want more granularity,
I
there is-
really don't. I really
Okay.
don't. I get it. I get it. The last thing I want is more granularity, frankly.
I understand.
But okay, let's move on to the second motion.
Your Honor, before we move on to the second motion, can I just make a record very quickly in response to what
Sure.
counsel said?
Yes.
Those issues are briefed nowhere in their motion for summary disposition. In addition to that, what we have given the court on that issue is Exhibit U to our brief talks about an initial notice with regard to load restrictions. A differing site condition claim, Your Honor, is independent than an extra work claim, such as what we're claiming under the special provision for blast cleaning. So, I mean, at the very least, Your Honor, the argument was never briefed by the department, and there's issues of material fact regarding those, especially since, again, the department has not provided any affidavit or testamentary support for those arguments. And before we leave the first motion, Your Honor, I do just want to make for the record the argument that under Michigan Supreme Court law, we have set forth what we believe to be the clear and convincing elements necessary to find a waiver and modification of the notice provision under this contract by virtue of the Attorney General's written direction to Atsalis to specifically submit the March claim as a condition of allowing Atsalis to continue its work on the project. If the department wanted to argue that we didn't give timely notice, the department waived its reliance on that clause by specifically instructing Atsalis it had to submit a claim in order to keep working on the project. Again, that evidence is undisputed, and we believe it's clear and convincing and sufficient to support a contract modification under Michigan law.
All right. Thank you, Mr. Vitiglio. Let's move on to the second motion. Let me grab my notes on the second one. Okay. Okay, the second one involves the claim that was submitted for the work that Atsalis claims the contract did not require it to perform. And who's going to address this one, Mr. Tuttle or Mr. Khan?
I will, Your Honor. You get me this time.
Okay. Okay, great. Well, always up for change, so we'll hear what you have to say.
I have a lot less to say than what you just heard on the first motion. I liken this motion, which is brought pursuant to 2.116 C4 to a motion to expand the record, say in the Court of Appeals, for example, because that's essentially the argument that's being made. What we need to do here is we need to first look at what the contract says with regard to the claims process, and then we need to look at two documents, specifically the claim that was submitted on May 28, 2020, and the factual underpinnings of it, and compare that to not only the complaint, but now the affidavit that has become, I suppose, a bit notorious based upon the first motion for summary disposition of Mr. Manis. I want to start first, if you don't mind, by quoting the contract language, because I think that gives us a good jumping off point, Your Honor, with regard to where we're going with this particular motion. I'm looking specifically at 104.10F, and there the provision reads in part, if the contractor's claim in any administrative proceeding or in the court of claims seeks relief greater than the amount sought at a prior level, or if the claim is based on facts or issues that differ from those presented at a prior level, the contractor has failed to exhaust its administrative remedies. Now, I'm going to point out that nobody has argued here that is anything other than clear and unambiguous. So we need to enforce the black letter of what's stated there. And as I read that, Your Honor, it reads to me to suggest that we need to look at the factual allegations that are made in the claim. And we need to look at the factual allegations that are made specifically in the complaint, and then in response even to the motion for summary disposition that we raised. Now, when you look at the claim, we have cited and block quoted actually at pages 15 and 16 of our brief, and I know you read it, the factual allegations that are contained within the May 28, 2020 claim and the correspondence that was attached to it. Now, to be fair to Atsalis, there were an additional 1,700 pages that were a part of that, and that was their direct cost submittal, just so Your Honor is aware. There's no argument there. We were looking at invoices and receipts and that sort of stuff. It doesn't provide the factual understanding that we get from the claim and its description of what the claim is. Now, when you look, and it's also, by the way, that letter, that claim is attached as Exhibit C if you want to look at it there as well. Now, the claim compared to the complaint is substantially different. The complaint has 97 factual paragraphs, which identify line, chapter, and verse the wrongs that MDOT is alleged to have perpetrated as a result of the ongoing contractual relationship between the parties. The complaint also provides, albeit in my opinion, a bit sparse, reliance upon particular provisions of the standard specifications for construction 2012, and how they interplay with the facts that have been alleged in the complaint. The complaint does more, however, because it also seeks substantive damages here. So I would be on insecure footing when talking about damages if we were talking about, for example, something like prejudgment interest, if they're requesting that, but they're not. They're actually asking for something along the lines of substance, including consequential damages, which are damages, as you know, Your Honor, that flow from the contract itself. So they're looking for, I'm sorry?
I'm going to say I tend to agree with you on the consequential damages. So,
Okay.
and the punitive damages, and Mr. Vitilio can put this in his notes to try to convince me, but there certainly are damages that are alleged in the complaint, punitive, consequential, special, whatever that means, and even potentially attorney fees and costs. I don't know if that was in the
I don't
filing
know.
I
apologize.
But no, I'm just saying, those I think are the clearest part of your argument. The part I'm tripping over in my head is, how can we possibly say that 1,700 pages of support for a claim that were specifically integrated into the filing is not specific enough? I mean, you understood it, your people understood it without question, what was being sought here. I'm having a hard time bringing myself to say, oh, for some reason, they failed to be specific enough in their claim for damages.
I
With 1,700 pages. Okay.
I wish I could tell you that I understood it, but I don't, because I reviewed all 1,700 pages prior to filing the present motion. The 1,700 pages include things like medical records, attorney's fees without any justification as to this is what the attorney was doing. They include charges for bottles of water, and they include, which I find a bit ironic, costs for seasonal exemption, where the parties had agreed to allow Atsalis to appear outside of the normal contractual timeframe, which is the construction season, which ends, I think it's on October 14th, but with the agreement that they would fully, completely bear the cost of those things. But those are included in their 1,700 pages as well. So what we don't have, Your Honor, is an explanation from them. This is why these are direct costs, because the statute, when it comes to, and this is a portion of this is why their request for summary disposition pursuant to I-2 is completely improper, because they didn't provide the depth of analysis that they even provided in their complaint. And I don't think their complaint addresses what those direct costs are. And certainly the request for I-2 relief doesn't identify what direct costs are.
Let me stop you. Where are you getting the phrase direct costs?
That comes from 103.02F, which is the section that Atsalis likes to point to argue that they're essentially entitled to anything and everything they had to incur as a result of their performance. You asked earlier, Your Honor, of Mr. Tuttle, are they claiming expenses for performing span 1 work? And specifically, the answer is yes. Mr. Tuttle answered it correctly, because they were required to what's called heat and house. And I'm learning as you're learning these painting terms, but because it's cold outside, they not only have to house the paint to make sure it doesn't freeze and heat it to make sure it doesn't freeze, but they have to do that to the bridge as well. And those were expenses that Atsalis had indicated it would incur itself, but those are included as a part of their 1,700 pages. So going
Okay,
back to,
I got it. I get that. But let me go back to 103.02F versus or compared to or standing next to 108.12. How do those two interact or work together or not interact and not work together?
an excellent question, and I was prepared for it, thankfully. 108.12 is the provision that allows for termination for convenience. And when you terminate under section 108.12, it provides, and I'm kind of a visual person sometimes, it provides, in my mind, a flow chart for how costs are supposed to be paid post-termination. So what 108.12 says is you go through and you determine if there are partially completed things, whether you're going to do it on a force account, which is defined in another section, or if you're going to do it on a partial payment of the total bid cost, I believe is the phrase that's used in that particular section. You then go down a little bit further, and there's a method for MDOT to buy back material that was purchased for the completion of partially completed items, bid items. Add a 15%, by the way, profit, so the contractor isn't out anything. It's actually a pretty fair way of doing things. And then it says, go to 103.02F for anything that was, yep.
Yeah, let me stop you because this is where I have a question about the meaning and Mr. Vitilio can help me understand it too. So I'll read it to you, these two sentences, and tell me what they mean. If the department terminates a portion of the contract, the department may stop delivery and payment for materials made unnecessary. Okay, so that sentence references materials. Then the next sentence says, the department will pay for pay items eliminated in their entirety by the termination in accordance with subsection 103.02F. And my question relates to pay items. Does pay items in turn sort of modify or relate to materials, or does pay items have a special meaning in this contract?
So pay items and the term bid items are essentially the same thing. So when you look at a contract with the state, and particularly with MDOT, because those are the ones I'm familiar with, there is a list of bid items where a contractor has to look at it and see essentially what their scope of work is going to be. And then sometimes you're given a quantity for what needs to be done. So for example, you could paint a bridge by linear foot, or you can do what happened in this particular instance, which is to identify in the bid item that it's a quote lump sum. And a lump sum bid item doesn't have the percentages or the ability to go back and take a look and do the math to figure out what amount is to be paid. And when you
Okay,
look,
so let me start again. So that the pay items has nothing to do with materials, but is a separate sort of term of art of these contracts.
that is correct. And what a bid
I
item.
just heard you say, stop for a second, because what I just heard you say, this says pay items, but are there pay items in this contract that are findable somewhere? I don't have the whole contract, by the way. I don't think I do, but are there is there a page of the contract that says here are the pay items?
There is, Your Honor. And what you do is you look at, essentially, if we were to give you the entire contract, the Michigan cases that you have behind you, you would have to move one of those bookshelves out to fit it in there. It's large, it's massive. So what we've endeavored to do is to provide you essentially what it is that we thought you need. But this particular question is a poignant one, and we probably should have provided you the bid items so you know what we're talking about, because essentially it looks like an Excel sheet with a description of work, and then there's a couple of columns, and the final column, if it's a lump sum, is the quantity essentially, or the amount that's to be paid for that particular thing. And we go through and we look at each of those things, and in terms of contract termination, so going back to this case for a moment, if you don't mind, when a contract is terminated for convenience, if it's terminated, for example, in the middle of the contract, and while the work was in the middle, this was actually at the end stages of when it was supposed to be completed, that's neither here nor there, 52% or thereabout is what was done on this particular contract. So there were, as a result of where the progress was, pay items that had not been started yet. No work had been done on them. And I can give you some examples because Carrie Warren gave examples. If you saw the question and answer that I cited in the reply brief that we filed, where she indicated that there was some railroad stuff. Off the top of her head, she thought there might be some traffic stuff that was eliminated in its entirety. So there are things that are eliminated in their entirety. And that's when you go to section 103.02F. And that comes directly from 108.12. Now, my understanding of Atsalis' argument is they want to do an end around that sentence and go directly to 103.02F. And they want to read that particular section, and they want to read it to mean that they get all of their costs, as Mr. Tuttle answered, and as I just told you that they're claiming in this particular case. So as opposed to limiting it to what 108.12 says, eliminated in their entirety, they are claiming that everything was eliminated in its entirety, which is not true. They had partially performed 52% of the contract. This is yet another reason why that their I-2 motion is completely improper here. And as a matter of fact, it's the question of fact in this particular one is baked into their count one claim because they received $519 and some odd $1,000 for their direct cost submittal, the rest of which was denied because they didn't believe it was, because MDOT did not believe it was direct cost. And this goes back to the heart of why I believe that their factual statement in their claim was not as specific as it is now. And the reason why I say that is because we didn't understand what their argument was as to why bottles of water and attorney's fees and medical expenses were all direct costs submitted for a pay item or a bid item. That was never identified in the 2 paragraphs in the 1,700 pages that they provided us. And Your Honor, the first motion for summary disposition, I was sitting here biting my tongue a little bit because there's a lot of technical information that's contained within this case and what a contractor knows and what a contractor believes. Even the answer when you were talking about, I don't think this RFI says, the response to the RFI says what you think it does. There's technical information that's contained in there as well. The point of this motion is to identify that Your Honor is correct. There is a lot of technical information here. And in order to be able to get to the court with a lot of that specific technical information resolved, we have the system set up to exhaust administrative remedies. They should have provided as much information as they possibly could have in order to explain how they believe their direct costs were at least preemptively not going to be paid. I think their claim puts the cart before the horse, but it's not our fault they put the cart before the horse. They should have waited till we made an adjudication and then filed their claim and then identified the specificity. So the argument that we couldn't have known what the department was going to do is merely a diversionary tactic because they should have. And go ahead.
Let me stop you for a second. I mean, I hear this, but it still doesn't make a whole lot of sense to me. Let's talk about your water bottle example. Okay. I presume, I mean, it's obvious to me that they're putting in a claim for water bottles does not represent, if we look at 108.12, it doesn't represent completed or partially completed work, but it does potentially relate to materials made unnecessary. I mean, to me, that's obvious. Why is that so hard? Either, and if your position is those materials were not compensable anyway, fine, don't pay for them. But it doesn't seem to me that it takes a rocket science or a scientist or an engineer to figure out what their claims related to, which of these 3 or 4 sentences.
Your Honor, that argument is akin to somebody coming to the Court of Appeals with all the wrong arguments or even no citation for a proposition and making the Court of Appeals do the research for them. They're required.
I hate to tell you, Mr. Cotton, I do that every day. We
I
all
know,
do. Okay.
Judge, I know you do, but I think you understand the point. They're supposed to come to us with the information that we can make a reasonable determination. And it's not our responsibility to justify whether or not that water was consumed for this project or that water was sent back packing to their warehouse and is still sitting in their fridge. They needed to come under the go ahead.
Right. But isn't the question now that they've submitted it and you've rejected it, isn't the question really, was your rejection of that reasonable or contractually supportable? Which seems to me to be a question bouncing us back to the question of fact.
No, because
they asked for it. Go ahead.
This is the time frame problem. Because they submitted a claim, it's essentially a preemptive claim for something they feared was going to happen. Instead of doing it the proper way, which would have been to submit the claim after they received their check for $519,000, saying, what about the other $12.2 million? What are we going to get with that? And identifying with specificity, we're entitled to it under this term. We use this stuff for this reason. We use this stuff for this reason. Identifying as it is under 108.12, all of the bid items that they were incurred under. As it stands right now, the 2 paragraphs that they provides none of that information. They could have provided that, Your Honor. They absolutely could have, and they still can, but they haven't. And
Okay.
in order for this to be,
I get it. Let's hear Mr. Vittillo's response.
Thank you. Your Honor, there are so many more undisputed facts that need to be considered in totality when Your Honor looks at the issue presented here. You need to start with the submission of the March 2020 claim that was the subject of the first motion for summary. The department denied that claim. At the time they denied that claim, and all of what I'm about to say, Your Honor, is presented in the record as part of our request for a summary under I-2. When the department denied that claim, they contemporaneously terminated the contract for convenience. At that time, the department had instructed Atsalis in the February AG letter to submit a claim for its quote actual costs. So that's what Atsalis did in the March 2020 claim. The department denied that claim. At the same time of the denial, they terminated for convenience under 108.12 and specifically said in that letter that compensation would be made under section 103.02F of the 2012 MDOT standard specifications for construction based on the elimination of pay items and or the partial completion of lump sum items. So at that time, Your Honor, the department specifically recognized how Atsalis was to be compensated for the disputed work that was performed.
Okay, so Atsalis, assuming you're correct, and Atsalis does then provide the, pages and pages, hundreds and thousands of pages of documentation, doesn't the state then still have the right to say, no, this wasn't necessary, no, this is puffing, no, this is expanding, you didn't need this, you didn't need this, you didn't do that, this wasn't called for under the contract, whatever defense it has. It just seems to me that even if you're right and the department essentially invited you to make this filing, it doesn't mean the department has to accept it all as payable.
You're absolutely correct. I agree with you, but that's not what happened. That's where the other facts come into play that are just being totally ignored in the
And when
presentation.
just let me say this, when you say the other facts come into play, the red light goes on in my head. There's too many fact questions here to grant summary disposition to you or to anybody in this case, because it's all sort of just swirling around. But tell me what facts are not in dispute, not what facts are in dispute.
Okay, sure. Yes, I appreciate that opportunity. So the undisputed facts are that once the department terminated for convenience and recognized its obligation to pay direct costs under 103.02F, Atsalis submitted its direct cost submittal. Well, even before I get to that, Your Honor, once the claim was denied in March of 2020, Atsalis followed the administrative claims process by filing a documented appeal with the DRB. So the crux of the department's motion here is that the lawsuit should be dismissed because we failed to comply with the administrative claims process. Well, when the claim was denied in March, we followed that process by filing a documented appeal with the DRB. That's in the record. And in response to that, the project engineer wrote an email terminating the DRB. That's in the record. So at that point, Your Honor, there is no claims process to follow under the contract. That is the overriding legal principle here when this court needs to be looking at how to determine this termination for convenience issue. Because the department terminated the contract for convenience. Then they eliminated the dispute resolution board, which is the claims process under the contract. And when they did that, there is no further claims process to follow. So how on earth could Atsalis how could they comply with a claims process under a contract that's been terminated? It's impossible. So when Ms. Warren terminated the DRB, and that's exhibit G to the affidavit, what we're left with is Atsalis providing its direct costs under 103.02F. And that's exactly what Atsalis did. And that is May 22nd. That's exhibit JJ. That is our direct cost submittal. And at this point, to answer your question about pay items, before you, exhibits A, B, and C are what called special provisions under the contract. And at the bottom of those special provisions are pay items. So a pay item is just the way that the department and the contractor identify the different items of work to be performed. And so translating the pay item issue into the termination for convenience issue, that's why it's so important and undisputed in this case that the department recognized its obligation to pay Atsalis for partially completed lump sum pay items under 103.02F. And that's right in the termination letter. So Atsalis submits its direct cost claim, not the claim, the direct cost submittal on May 22nd. The department does not answer that until August. Okay, now under 108.12, under the contract, that clause requires a contractor to submit, it's on page 85 of the standard specifications. It's Exhibit J to our brief. So in 108.12, at the top of page 85, it says the contractor must submit any claim for additional compensation not covered in the contract within 60 days after the effective termination date. So what we have is after Atsalis gave its direct cost submittal on May 22nd, to which the department had yet to respond, out of an abundance of caution, Atsalis submitted a claim to comply with that 60-day requirement under 108.12. And all that claim said, Your Honor, that's the May 2020 claim. All that claim said is that, and that's exhibit, that's exhibit KK. So the May 28 claim was intended to comply with the 60-day timing requirement under 108.12. And all that claim says is we've submitted our direct costs on May 22nd, 6 days before. You have yet to give us an answer to that. And we are submitting this claim to protect ourselves under the 60-day timing requirement. And what's important to note is that at that time, the contract had been terminated and the administrative claims process had been terminated because the department disbanded the DRB. There was no way for any further administrative relief at that time. So with regard to the specific issue of the May 28 claim, it's also undisputed in this case on the record before Your Honor that the department never answered that claim. It went without response. Instead, the department on August 7th, which is Exhibit LL, answers our May 22 direct cost submittal. So on August 7th, they answer the direct cost submittal. And again, at that time, the contract is terminated. There is no more DRB. And so to answer counsel's assertion that we should have submitted a claim at that time, how? There's no contract. There's no DRB. There's no further administrative process to follow. And if Your Honor looks at Exhibit LL, that is where the specific quote unquote pay items are identified by the department in their compensation summary. So in the attachment where they recognized an obligation to pay $500 and some thousand, the specific issue here, Your Honor, is that they only paid Atsalis for the negotiated contract unit prices for all the pre-termination work. And that's borne out in Exhibit LL, and that's borne out in the admissions of their corporate rep at the deposition. And that's undisputed. They don't argue that they didn't pay direct costs for pre-termination work. They only argue that somehow 103.02F just doesn't apply when the contract clearly applies to all pay items that are eliminated. The facts show that certainly all pay items were eliminated. They told us to submit our direct costs under 103.02. We did that. and they didn't pay us for that. And
Okay,
when that
I get it.
and so
All right.
just to, when that happened, there is no administrative claims process to follow, and that's why we brought the suit, Your Honor. And that's why we're asking for judgment under I-2. The language of the contract is clear on what is owed under a termination for convenience. And the case law I've given, Your Honor, the whole point of a termination for convenience under a construction contract is to convert a fixed price contract into cost reimbursement. So we can argue whether a water bottle is a fair and equitable direct costs, but the department never even entertained that discussion. They refused. And that's what led to the filing of the suit. And it's our position, Your Honor. I mean, that is the start, middle, and end of this lawsuit, is what is owed our client after the termination for convenience under 103.02. And that's why we've asked for judgment under I-2. And the department presents no contradictory evidence whatsoever.
May I, Your Honor?
Yes.
Let's start with that last point. He cites LL. We provide there the compensation summary, which refutes his statement there, or his client's statement there, because the spreadsheet identifies what we believe is compensable and what we believe is not. That's your baked in question of fact under count one.
And that is LL, so you're both referring to LL?
That is correct. That is it's the attachment to that letter. There's a spreadsheet there of how MDOT determined what compensation would be. We paid the $519,776.01. So the other thing that you heard is something that I kind of predicted would happen. And instead of relying upon the clear and unambiguous nature of the contract, what Atsalis likes to do is jump the shark and go right to 103.02F. And Atsalis did that in relying upon the letter, which is Exhibit EE, I believe. They like to quote the sentence that refers to 103.02F. But if Your Honor recalls, when I was talking about how compensation post-termination works, we start with 108.12, and that kind of works as a flow chart to tell you where to go. And the sentence before that is exactly what we were saying. You start at 108.12, and then you move on from there. That's the interpretation of the contract, because that's the way it goes. You can't take one sentence out of context and make it so. And that's not only what was done with regard to this, where we said that Atsalis is entitled to compensation for any partially completed work as of March 31 in accordance with section 108.12. But it also happens in the case law that counsel just cited, which is really strange. There is no case law that cites 108.12. So we go to federal procedures for that, and the CFRs in particular, and how they've been interpreted. And when you do that, you see that there's actually protection within the federal statutes, which prohibits obtaining more than the contract value. So the underlying intent is actually to do something that counsel doesn't want the court to know, which is to avoid the natural consequences of breach of contract for the government. And that's been completely swept under the rug here. And instead, what we're doing is we're trying to say, no, we're entitled to get everything that we incurred on a cost basis, as counsel just argued. But that's where the absurd result under the contract comes in, Your Honor, because we're not talking about direct costs and all these costs and everything else. We have to examine the elimination of pay items. And counsel referred to, he said Exhibit A, B, and C. What we're really talking about is Exhibit A, B, and C to Mr. Manis's affidavit. And each one of those that he's referencing, they were paid partially under. So he doesn't get, or his client doesn't get, the entirety of what they're asking for in their direct cost submittal, but that's exactly what they asked for. And under the administrative process, we should have been told why they thought they were entitled to it. That's the purpose for exhausting administrative remedies. Now, the other thing, and this is kind of how we started our conversation, is there was the damages that you agreed with me with regard to consequential damages, punitive damages, special damages, whatever those might be. There's no response to that in their brief. They don't argue it once. And again, today, there was no response to that. But I might add, there was the the administrative remedy had been terminated. I find that argument a bit suspicious, only because if the administrative process had been terminated as well, why did they submit a claim on May 28, 2020? And one more than that, if the payment of $519,000 in change was not a response to the May 28, 2020 claim, then one, that money should probably be tendered back. And two, there's still an open claim that needs to be adjudicated. And that's even more reason for this case to be remanded back, because the court doesn't have subject matter jurisdiction. If that's the position they're going to take, then they need to follow it to its natural conclusion, which is there's still more stuff to do before we come back to the court. I think all of those reasons are why, Your Honor, under the contract, the administrative remedy process hasn't been resolved. It meets with the intent of the administrative process, as we both agree is the intent of the administrative process. We both cite the same factors. So the question comes down to, did they do what they were supposed to do, or is there more work to be done? And by submitting additional information and requesting additional damages, there is clearly more work to be done. And that work needs to be done in the administrative process, not before Your Honor. Your Honor, you're on mute.
Do you want to give a 2-minute, no more than that response, since some of that was directed at the motion on which you have the burden?
Yeah, I appreciate that, Your Honor. There's no genuine issue of material fact that the department did not pay direct costs for pre-termination work. That is undisputed, and it's a matter of pure contract interpretation for Your Honor to determine whether they had to pay those costs under 103.02F. And we addressed that squarely in our response brief.
Okay, you're repeating yourself now, and I get it. So let's call a halt to these arguments on the two motions. And I'm going to get back to the motions in a second, but I want to throw out two questions, one of which is a request. So at least approximately a month has gone by since we had our last meeting regarding outstanding discovery issues. I would like to ask both sides to send a letter to the court recommending or stating which discovery issues in your view remain outstanding should the court deny all the motions for summary disposition, and the order in which, in your view, the court should address the outstanding discovery disputes in order to most assist the parties, in order to provide the greatest assistance to the parties. Okay, that's number one. Any questions about that before I move to number two? Okay, if you can get that, go ahead, Mr. Vitilio.
My two questions, Your Honor. One would be, would you like the other side to receive a copy of our letters?
Yes, share them with each other. Send them to me and do it in about 2 weeks, within the next 2 weeks. I know there's a holiday coming up and I don't want to make anybody crazy. So, in about 2 weeks, if it's 2 weeks and 3 days, the court doesn't care. So,
okay.
something in that neighborhood.
And
Would you like those e-filed, Your Honor?
E-filed, and our clerk will get them to me. So e-file them with the like you always do.
And the content of the letter, Your Honor, is it limited to the pending motions or just anything that
No,
could be?
forget the motions. The motions I'm going to work on. In fact, I'm going to ask our court reporter, tell her that I want a copy of this transcript. So, I need the transcript before I can feel that I've addressed all the motions in the way I want to address them. So that's going to take some time.
Yeah, I'm sorry. I was referring to the pending, there's pending discovery motions, so.
I
that's-
know, that's what I'm addressing with this request to you.
Okay,
A pile, I showed it to you last time. There's a pile of discovery motions. And I started this by saying, I presume, or maybe this is just wishful thinking, that some of them have gone by the wayside because you've worked it out. But maybe, as I said, that's not the case. But I want to know, I want each of you to tell me which motions you would like the court to address and in which order, in order to most help this case move forward. Does that help, Mr. Vitilio?
yes, ma'am. Thank you.
So that's number one. Here's number two. Question. I'm going to give you both a chance to answer. The more I read, the more I listen today, the more I'm convinced that this case, you guys can waste each other's time, not waste, but spend each other's time fighting, for a long time. Is there any chance that we can do an early facilitation, not with me, but with a facilitator, to see if the $12 million that are in dispute can be, whittled down to some number that's acceptable to both of you? Attorneys General, what is your view? Or is it, and I'm going to ask you second, Mr. Vitilio. So tell me if it's not worth it at this point because not enough discovery has been done. Fine, I accept that. If there's any chance it is worth it, tell me that, and we can then move on to trying to find a facilitator or a process.
Your Honor, there is a possibility of settlement, we believe. We believe, though, that the other side needs to come down a lot more from where they're at. We think there's been a lot of admissions on the record that support them lessening their demands. We don't believe in the facilitators actually necessary, provided that the other side wants to come down. But
so do you believe that the two parties, the two sides can get together and talk again if the court orders it, or you can do it on your own, or what process would you recommend?
Your Honor, we actually requested an updated demand from counsel pretty close to a month ago now. And I understand that values and so on and so forth, not only are we in public, but because
Okay.
you're the ultimate trier of fact,
Right.
you can't be privy to those. There was a settlement demand. There was a settlement offer, and there was no response. So at this juncture, I don't know if we were waiting for the motions to be heard or what we're doing, but we've always hoped that we could work together to resolve not only the discovery issues, but also the case as an entirety. We're open to that, but we need to have some dialogue, frankly.
Okay, so what I'm hearing from you is my translation of what you both just said is that you would like to continue informally trying to approach a settlement rather than having an outside facilitator brought in and brought up to speed and paid for and blah, blah. Is that right?
yes, Your Honor. Given, as you've noted, there's so much to go over, we don't feel it would be efficient to bring in a facilitator and bring them up to speed as well.
Okay. Mr. Vitilio, your perspective.
Your Honor, I'm really taken aback here because it's incredible to hear that they think there can be a dialogue between us when in May, they put into writing that they would not have any conversations with me whatsoever on a telephone. Everything.
Okay, well, let's try to get past being angry and just try to move this along.
Sure. So in May, I've asked 3 times for a facilitator, Your Honor. I gave them 5 or 6 names. They've rejected it. So
Okay, well, what about their idea? Let me stop you. What about their idea that you do come to a table together, maybe a Zoom table, a virtual table, but that before you get to the facilitator, that you have to pay thousands of dollars, in this case, likely, to even understand the underlying issues? Why not a couple of sessions together to try to work it out?
I'm all for that, Your Honor. I just tend to think that facilitation and getting a knowledgeable construction attorney that, I mean, there's facilitators that specialize in construction disputes like this. They're invaluable. And so that's why I asked for it back in May. But I have no, if they're willing to talk to me on the phone now, that's a new revelation to me.
Okay, well, then I would like to, there's a second thing then I'm going to request that you do. And that is that I would like to, both of you, to give me a report, send the court a report in 28 days, just indicating whether or not, in your view, there has been any productive settlement discussion. Yes, you know, it's a very easy question to answer. Has in the last 28 days, there has been productive settlement discussion, or there has not been productive settlement discussion. And then I will determine, or think about, or maybe call you back together to decide whether we will go the route of a facilitator. But I'm going to give you 28 days. That should be enough time to at least get started on something, if it's possible.
Do you want that to be a joint letter to the court, Your Honor?
No, just send it to me separately. I think you guys have trouble doing things together. So playing together does not seem to be in the cards here. So let's have you write separate letters.
Also e-filed.
Pardon? E-filed,
Also
right.
e-filed? Yeah, okay.
And, you know, very brief, no drama, no, you know, you don't need to go into any details. Just tell me whether there has been.
Okay.
Okay. Okay, now, before we close, Ms. Roberts, I would like a copy of today's transcript. I don't know the process for my court doing that. You and I can talk later, or you can just tell me it's, you know, it's
done. It's done, Judge. Just by you saying it.
Okay, good. And I know Ms. Roberts would like to know if either of you guys would like one, or what, or does my ordering one allow you to get a copy? I don't know how it works in this setting.
They have to order their own copies.
Okay.
We would like a copy.
Pay for their own copies.
We would like a copy, please.
We would too. Thank you.
Okay. All right. Now, is there anything else you would like to bring to my attention today? Anyone?
Not for me, Your Honor.
There is one thing, Your Honor. We're talking for a letter regarding the outstanding discovery in 2 weeks.
Okay.
As it's set, discovery for depositions only per the last order that was entered is set to expire on September 13. We've asked, and in the line of we're not playing well together in the sandbox, we haven't been able to agree on a stipulated order to extend discovery. Given that we're coming up on that deadline and the discovery motions won't be heard essentially around the same time, can the court entertain, or will the court entertain an adjournment of discovery?
Yes, the court will not only entertain it, you can consider that date dissolved as of this moment. You may consider it dissolved, and let me then add, I'm glad you brought that up. Let me then add to your assignment in the discovery, what I'll call the discovery letter rather than the settlement letter, add in the discovery letter, each side separately, how much time you think you need. And I'll make a decision based on that.
Thank you, Your Honor.
Okay.
Mr.
Thank you
Judge, are you done? I wanted to make a request of Mr. Tuttle.
Sure, I'm done. Unless they have anything else to add, Mr. Tuttle, you would look like you want to add something.
Mr. Tuttle, the construction language I'm not familiar with. Would you mind emailing me what you read from the beginning? You were reading in the beginning, right when you started, right?
Yes.
Okay. Can you write down my email address?
I got it. Go ahead.
T like Tom, H like Harry, R like Robert, S like Sam, Lynn, my middle name, LYNN, @comcast.net.
Let me confirm. It's THRSLYNN @comcast.net.
Correct.
Got it.
Okay, and Mr. Khan, what is your first name again? What did you say?
It's Eric with a C.
Oh, Eric
E-R-I-C.
ERIC, Eric. Okay, thank you. That's all I need to know. Goodbye.
Thank you, Ms. Roberts. In fact, we'll go out, we'll say goodbye to you because whatever we do now doesn't need to be on the record. Just any final.
Okay. Everybody
Thanks.
have a great day. I'm gonna leave.
Thank you. You
Ms.
too.
Roberts. Ms. Roberts, thank you very much. Are we okay on everything else?
Yep,
If
yep.
we aren't, send the court a letter through file it with the court, with the way you normally file things, and it gets to me the same day. And I'll do my best to address it.
Thank you, Your Honor.
Okay.
Thank you.
Thank you.
Have
Bye.
a good rest of month. I'm
You
sure I'll
too.
see you in September or thereafter. Okay. Bye.
Bye.